All right, so they've requested a travel.
And I'm standing in for AD Samantha Brown. She has no issue with that, Your Honor.
Okay. All right, so what we'll do is you'll be allowed to travel, but you're going to have to do a UA when you return. Do you understand?
Yes, ma'am. That's
Right.
perfectly fine.
All right, and you'll just do that through your probation.
Yes, ma'am. I need to email my probation officer to let him know about the travel permit as well?
Oh, I'm signing the document now, and so
Okay.
they'll receive it.
Okay.
All right, is there anything else?
Nothing else,
No,
Your Honor?
ma'am.
Are you doing well on probation?
Yes, ma'am. I already finished anger management, hostility management. I am about halfway through MRT. I'm ahead on my payments for probation and just moving forward.
All right, great. Keep up the good work. Again, if you need anything, just let us know, okay?
All right. Thank you so much. I hope you have a great day.
Oh, thank you. I'm going to do my best. And thank you for dressing appropriately for court and being on time.
You're welcome. Thank you for everything.
All right, bye-bye.
Bye-bye.
All right, just make sure, Vashawn, on this case, they'll give you, I guess, a copy if you need it. All right, so if you'll have a copy made
Yes, Judge.
and then give the original back to the clerk, but if you'll make a copy for Miss Abrams. All right, thank
May I
you.
be excused?
Yes, thank you. Yes.
Thank you, Judge. Have a great day.
All right, you too. Bye-bye.
Bye-bye.
Thank you.
All right, we're here on DeAnthony Gortley. And I think it's for a bond reduction. All right. Are you ready to proceed on this?
Yes, Judge.
All right, the court is calling 2025 CR 00706 State versus DeAnthony Germonte Gordley. Could I have parties announced?
Dr. Whitlock for the state of Texas.
Robert Ramirez for Mr. Gordley, Your Honor.
All right, and Mr. Gordley is here by Zoom. Defense, do you have any objection to your client being present by Zoom?
No, Your Honor.
State any objections?
No, Judge.
All right, Mr. Gordley, if you can unmute for me, please. All right, hello. Mr. Gordley, you're appearing by Zoom. You can be allowed to appear in person in court. Do you have any objections to appearing by Zoom?
No, ma'am.
All right, so I'm going to mute you now and again.
Here's where things heat up. The defense is asking for a PR bond. That's a personal recognizance bond, meaning Mr. Gartley could be released without paying cash, based solely on his promise to appear. But Judge Boyd makes it clear, her hands are tied by Texas law. Since Gartley is charged with harassment of a public servant, state law automatically blocks PR bonds. This is a critical point. Judges often explain that it's not about personal feelings, but about legal limits. What do you think? Should judges have more discretion in these cases, or is the law right to take that decision out of their hands?
Because sometimes there's noise that comes from your end because it's at the jail. So, all right. All right, so we're here on defense motion requesting a PR bond or either to reduce bond. Is there an agreement or no?
The state does not believe there's an agreement.
All right, and state you're opposed to the PR bond?
Yes, Judge.
All right, and why are you opposed to the PR bond?
The state would argue just the type of offense and that the state believes the original bond set, I believe it was
500
would be appropriate for this offense. And yeah, that's the state.
All right, so, and defense, what I can tell you is based upon what he's charged with and based upon the new, based upon what the governor has stated and given to the court, I'm not allowed to give him a PR bond for harassment of a public servant. Those are not my rules. These are the rules that I must follow. I tell everyone, it doesn't matter how I feel about something. I'm just going to follow the law. So he's not entitled to a PR bond. The court is not going to grant him a PR bond. We can talk about the bond reduction though. And if you would like to present evidence,
Yes, Your Honor. I'd like to call my client to testify on this case.
all right, Mr. Gartley, if you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
D'Anthony Germonte Gordley.
All right, sir, you may proceed.
Mr. Gordley, have you tried to make bond on the 7,500?
Yes, sir, I have.
And why have you not been successful?
I don't have like the resources or the people out there to help me. So I've been in here by myself trying to do it.
Well, what about your mother and father?
They're both deceased.
Okay. And I was aware of that when I asked that question. I just wanted to make that for the court. Well, what do you do for a living?
I dance and basically just make videos, and I work
Okay.
when I can, but I can't right now.
Were you able to save up any money while you were working as a dancer and making videos?
This is heartbreaking. Gartley reveals he's lost both parents, has no financial support system, and makes his living as a dancer and social media creator. He even points out that since being locked up for months, he can't generate income from his online platforms. Notice how the defense highlights these details. It's all about showing the court that the $7,500 bond is completely out of reach. But here's the legal reality. Bond isn't supposed to punish someone for being poor. It's meant to ensure they return to court. So the judge now faces a delicate balancing act. How low can she go while still keeping the system's trust intact?
I was, but I don't have any access to my funds because I don't have my wallet in here, nor do I have my phone.
Okay. I've spoken with your sister. Has your sister been able to make contact with these funds?
No.
Okay. And where does she live?
She actually lives with someone that I don't even know.
Okay. But she's not in San Antonio area?
She's just not stable.
Okay. So, okay. But you understand that you would have to make, we talked about the PR bond. The court just told us that this offense does not qualify as a PR bond. So if the court could reduce the bond to a certain amount, would you be able to possibly make that with possible assistance from outside?
I'm not 100% sure, but it's possible. It's possible.
Okay. All right. I have no further questions, Your Honor.
All right, any questions?
No questions from the state, Your Honor.
All right. Mr. Gortley, I just have a few questions. Any objections to the court asking a few questions?
No, Your Honor.
None from the state.
All right, Mr. Gortley, have you ever had any type of diagnosis for mental health issues?
When I was younger, I think it was ADHD, but I don't, nothing since I've been grown.
Have you ever been prescribed any type of medications for mental health?
Not that I know of, no, ma'am.
All right. Have you ever in the past used any type of controlled substances?
If weed is a controlled substance, yes.
Yeah, it counts as a controlled substance.
Well, yes, ma'am.
Anything other than that?
No, ma'am.
All right. And do you have any type of, I know your counsel said that, asked you whether or not you had funds, and you said you don't have any access to those funds. Is that correct?
Yes, ma'am, correct.
All right. So if you had access to funds, how much approximately would you have access to?
Honestly, I wouldn't be able to tell you that exact amount because so I get paid from Facebook and Instagram and TikTok and stuff like that because I post videos. So I don't know. It varies every month. It varies. It could be 200. It could be 1,000. It could be something within that range. But I don't know for sure because I didn't get to post as many videos as I did since I've been in here. I've been in here going on 5 months now. So I don't have. I wouldn't be able to tell you exactly what's there because it's not residual income.
Okay. And I have no further questions. Oh, I'm sorry. One more question. If you are able to make bond, where would you have a place to live?
Yes, I will.
Would you be living with anyone?
Yes, I would.
And who would you be living with?
Most likely my girlfriend.
And does she have any children?
No, ma'am.
All right, so there would be no minors in the home?
No, ma'am.
All right, thank you.
These questions might seem personal, but they're absolutely strategic. By asking about mental health diagnoses, substance use, and stable housing, the judge is gathering evidence for risk assessment. Courts weigh 3 big factors when deciding bond, flight risk, financial resources, and danger to the community. Here, the judge is piecing together whether Gartley can live safely in the community and whether he's reliable enough to return for trial. It's fascinating to watch. The courtroom isn't just about guilt or innocence, it's also about predicting future behavior.
All right, State, do you have any information on Mr. Gartley's criminal history?
Yes, Judge, give me one moment. The state sees minimal juvenile history, but in 2018, probation for an unlawful carry of weapon. And that would be the extent of the history, Your Honor.
All right, no violent history?
No violence.
All right. Then, Mr. Gartley, one final question. What amount of bond are you able to make?
Honest, I don't have any funds right now. Like I would have to reach out to my people and see what they will be able to come up with, but I wouldn't be able to even tell you a number. I don't even want to lie to you, Judge.
Oh, no. I'm just trying to figure things out. All right, so the court is going to grant the motion to reduce bond. State, I know that you're not in agreement to the reduction of the bond, but you now know that the court is going to reduce the bond.
Yes, Judge.
So is there any request from the state with regards to a reduction in the bond?
The state would rather hear defense's suggestion and be able to agree with it. if
All right,
that's
thank you.
possible.
Yes. All right, defense, what are you requesting for a bond amount?
$500, Your Honor.
The state was hoping he'd say 1,000, but the state would not make a very effortful fight against said suggestion.
All right, I'm going to set his bond at $1,500. There's to be no residing with minors. All right, and if for some reason he's unable to make the $1,500, counsel, you can always come back and you can come back immediately. But
Your Honor.
my hands are tied, and we can go off the record. My hands are tied in the sense that he hasn't really expressed to the court the amount of money he has access to. So we'll start out with $1,500 and see where we are.
Yes, Your Honor.
All right, thank you.
Thank you, Your Honor.
Thank you.
You're
Thank y'all
welcome.
so much.
Thank you.
Thank you all. That being all may be excused, Your Honor.
Yes,
Okay.
9:40.
yes.
I'm just trying to check, Judge, to make sure my client is on Zoom. It should be Noriega.
All right, it's somebody with a Samsung. Is that her?
I wouldn't know because I didn't log on because I was in court this morning, so I just came up.
All right, the person with Samsung, if you could unmute, please, and show your video.
Hello?
Hello, if you could start your video, please.
There. Okay.
Oh, hi.
Hi.
All right,
That's
so
her, Judge.
yes. So on Noriega, have we figured out?
I think Ms. Abrams may want to give the court an update.
Okay, Judge. All right.
Apologize.
Oh, no problem. So what is the update?
Okay, so Judge, Miss Noriega, the last time she was here in court, not yesterday, but previous to yesterday, because I wasn't here, she indicated to me she was going through bankruptcy.
Yes.
I wanted to make sure that the court was aware of that. What I found out as far as her fees are concerned is, the original assessed fees total combined was $8,879.75. Of that, the restitution was $5,448.75.
Mhm.
The probation fees that she's paid is $1,108. The restitution that has been paid was $2,454.57.
I'm sorry, 2,000. Oh, thank you.
Have this, Judge, I wrote on there.
Okay, thank you.
So the remaining balance of the restitution, you can see is a little over $2,000. Even if we do a modification priority of fees, they're not gonna get, they're only gonna get $1,100
Mhm.
for that
2,000.
$2,994. I did print out a modification of fees for that, in case the court wants to go ahead and sign it. It is to Xerox, the Xerox Corporation. At this time, probation is just asking for the case to be terminated.
All right, so if you're saying that $1,100 would go to the 2,900?
Yes, Judge.
Okay. All right, and as a part of her bankruptcy, I'm familiar with bankruptcy, not from my own personal that I've had bankruptcy, but I've known other attorneys who practice bankruptcy law. And usually, if you're going through a bankruptcy, all of your debt is within that bankruptcy, and people will claim their debt and the creditors will be in line. Now, it's been a while since I've been in law school, so I don't remember. I think it's secured creditors
get
come
first.
first. And then, so Xerox should be in that line of creditors in the bankruptcy. It should come up that she owes them money. And so that's a civil matter. So here's my question. Other than the remaining balance of the approximately $1,300, which Xerox should get through the bankruptcy, is there anything else that she has not completed?
No, Judge, and I'm sorry, you said 1,300?
Well, you said you're taking like $1,100 away from the 2,900.
If you sign the modification of fees, Judge.
I'm going to sign the modification of fees. So then,
She's
that-
completed everything else.
all right. All right. So here's the thing, Miss Noriega.
Yes, ma'am. I wanted to say something.
Yes.
Okay, so the bankruptcy, because I live with my dad. I take care of my elderly dad. He's 80 years old. And we had a situation where my sister was in charge of his finances and she was taking his money. So the house wasn't getting paid, and that's why my dad is in the bankruptcy. I help him because I live with him. I'm not the one in the bankruptcy, my dad is, but I help him contribute because he gets Social Security and a VA check, and that money goes to the bankruptcy payment is $1,230. So all my other monies that I get, I pay towards everything else, and that really leaves me with nothing. But I mean, I was not going to pay one of my bills so I can, contribute to what I owe.
So, all right. Well, I thought she was in bankruptcy, but it is not. It's her father.
No, it's my dad. Yes.
Me too.
All right. So then you're not in bankruptcy. The money needs to be paid to Xerox. So how much are you able to contribute to Xerox?
How much time do I have?
Just give me one moment.
Okay.
See. All right, so her balance then will be approximately $1,300. So once you pay the $1,300, the court will terminate your probation.
Yes,
So
ma'am.
when are you able to pay that?
I'm not sure. I would have to make payments. I mean, at this point, I mean, I'm already, financial burden, but I'll figure something out. I don't know when I can actually have it all, but I'll pay something every week because I get paid weekly. I can
Mhm.
pay, I mean, at least $100 a week. I'll start paying that.
Okay. All right. Thank you so much. Probation will be in contact with you, okay?
Okay,
All right. Thank you.
thank you.
All right, Charles Smith, come down. Court is calling 2024 CR 1894 State versus Charles Smith. Can I have parties announced?
Justin Whitlock for the state of Texas. Scott Simpson for Mr. Smith.
And are you Mr. Smith?
Yes, ma'am.
Counsel, have you received all discovery in this case and did you review it with your client?
I have, and I did.
Court will find that the state is in compliance with discovery. Is there an application in this case?
Yes, Judge. For regular, not for deferred.
All right, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we are not. We are proceeding with the lesser included attempted fraud use possession to make this a class A misdemeanor.
Any objections?
No objections, Judge.
Did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand the state is proceeding on the lesser included offense of attempted fraudulent use or possession of identifying information less than 5 as a class A misdemeanor? Range of punishment is up to a year in the Bexar County Jail and up to a $4,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Very much so.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Smith, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand that?
Yes, ma'am.
According to the plea, punishment is to be assessed at 365 days in the Bexar County Jail. The state recommends community supervision. There's to be restitution to St. Peter and Paul of $1,940. There's to be no contact with St. Peter and Paul and the MRT. Did you understand that to be a plea?
Yes, ma'am.
Defense, is that the plea?
It is.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
None.
Outside the agreement, the state is recommending their community supervision be for a term of 2 years. There be 100 hours community service restitution and no contact with St. Peter's and Paul. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense, the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
State offers States Exhibit 1 and all attachments at this time, Your Honor.
And we've reviewed those, Judge. We have no objections.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. So here's my question. Did Frost Bank receive their money back or no?
No, I don't think.
Or did Frost?
Adopt it, so the complainant would be good, but I do believe Frost may be out.
All right, so do we know if Frost is out of 1900?
I can call and confirm. What I do know is that based on the STIPs, there were multiple missing things, but the state did limit to defendants' participation. But the state can get a confirmation and if there will be a restitution hearing.
I believe in what I've worked on it, that restitution was not made yet to Frost. My client understands that and is prepared to, knows he has to pay that over the course of his probation. We've already calculated how much he has to pay each month to get it caught up. So I think it should be ordered, Judge.
All right, and so with regards to the $1,900, when do you expect you'll be able to pay that?
How many months?
I can do it within 2 months if I need to.
To be realistic, don't.
Realistically, within a year.
6.
Yes, 6 months to a year.
So how much money can you pay down?
Down
Today, like today. You're talking today, right, Judge?
Yes.
today, 0. Just in all honesty.
All right, so when will you be able to make a payment of $800?
Next Friday.
All right, so what I'm gonna do is I'm gonna reset this for next Friday. You're to come in with a payment of $800. Probation,
Following Monday, Judge.
the following Monday? All right. Oh, yes, no,
Thank you.
What date is that, Judge?
let me pull you up. The 28th,
28th of July.
January 28th.
Yes,
I'm
ma'am.
sorry, July 28th.
Yes, ma'am, absolutely.
Also, we're gonna recall for July 28th,
For 800.
and you're to make a payment of $800.
And
And who does he make that out to? Probation, state?
Actually, it's gonna be part of the state, if it's not.
Well, I'll communicate with the prosecutor between now and then, Judge, but it's gonna have to be in a cashier check or money order. So I'll get that info to you and I'll talk to Mr. Pitluck.
All right, and then your client was late today.
I understand, Judge.
Yes.
I would ask if you could recall the warrant and let him out so he can get this money
Yeah.
for next Monday.
State, do you have any objection to the court recalling the warrant so that he can obtain payment?
No objection from the state, Your Honor.
All right, we'll recall the warrant.
thank you, Judge.
All right, thank you. Make sure you're on time. So your next court date is going to be July 28th. They're going to give you a reset form. Court is in the courtroom, okay?
Yes, ma'am, absolutely.
All right, thank you. And Deputy Laura, could you see if the jurors are all here? Who's here on Victoria Sanchez?
Here for her, Judge.
Court is calling 2020 CR 2715 State versus Victoria Sanchez. Can I have parties announced?
Deputy Pitlock for the state of Texas, Your Honor.
Come forward.
Ted Wood representing Ms. Sanchez.
And are you Ms. Sanchez?
Yes, sir. Yes, sir.
All right. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney?
Yes, ma'am.
And also the First Amendment motion with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Are you the same Victoria Marie Sanchez who was placed on deferred adjudication in 2020 CR 2715 for the offense of possession of a controlled substance penalty group 1 gram to 4 grams on August 5th, 2020 for a period of 2 years? Is that you?
Yes, ma'am.
And extended for a total of 5 years?
Yes, ma'am.
All right, state.
Yes, Your Honor. Violation of condition number 28. On or about the 11th day of April 2025 in Liberty County, Texas, the defendant Victoria Sanchez did then and there fail to comply with the rules, regulations, or instructions of the Bexar County Community Supervision and Corrections Department Substance Abuse Felony Punishment Facility Continuum of Care Treatment Plan, and that the defendant was unsuccessfully discharged for refusing to participate in treatment Violation of condition number 28.
All right, so what motion are you reading from? Because I don't see a violation of 28 on mine.
This one provided, it's under case number ending in 2715.
Is it a supplemental or something?
No, Judge, it was signed 5/13/2025.
May I show the court?
Yes, because I don't have that one. Okay, yes, I've been given the wrong paperwork. Okay,
Rely on the defense to give you the right paperwork.
okay. So to that allegation, how do you plead? True or not true?
True, Your Honor.
State, do you waive? Is that the only allegation?
Seeing that this is the only violation.
All right, yeah, I definitely didn't have the correct paperwork. All right. Did you understand by pleading true to violation of condition number 28, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition 28?
Yes, Your Honor.
Court will find violation of condition number 28 true. Is there a proposed agreement?
There's not, we are going open, Your Honor.
All right, state, what are you requesting?
The state is requesting that you grant the state's motion, revoke probationer and sentence probationer to 2 years TDC.
And defense, what are you recommending?
Judge, right now, this morning, Ms. Sanchez has 180 days credit. I'm asking the court to find her guilty of the lesser included offense of attempt to possess controlled substance 1 to 4, which is a state jail, and sentence her to 180 days in state jail, time served, judgment satisfied.
All right, why would I do that? She hasn't been successful.
Because you're a merciful and just judge.
Yes, but she has been, this is not our first motion to revoke.
It's not, Judge, and I think that Ms. Sanchez is having difficulty utilizing the resources available through SafeP. I don't think that there's any sort of remediation that is available to her that's going to help her move forward with her life. And Judge, I'm asking that you sentence her to 180 days, time served, judgment satisfied, so that she can get out, rebuild her life. Judge, she's a victim of sexual violence, and I'm hoping that when she does get out, that she can link up with Center for Healthcare Services and get some trauma therapy so that she can go forward with the rest of her life.
All right, and you have children?
Yes, Your Honor, I have 4.
All right, and see, that's the problem because she was here when I placed her on deferred adjudication. I placed her on 2 years deferred adjudication, gave her all the tools that she could need, had her saying, work with CPS, had contacts for her for outpatient treatment, intensive outpatient treatment, did a referral to felony drug court. Then there was a violation and still continued her, did the weekly Zoom reporting to try to get her on track. And then there was another violation, and then she was sent to SafeP. So I'm not going to give you a judgment satisfied. I'm finding, and did you complete the CPS?
Yes, Your Honor. I'm actually getting my visitations. I was paying my child support for about 8 months. The last time you sent me for the 2 years, within those 2 years, I did 8 months, I think up to 9 months of job and paying my child support, and I was seeing my kids. So I mean, right now I'm really having a hard time with my son. He just started middle school, so
Well, you know why you're having a hard time with your son? Because you're not in his life.
Exactly.
All you had to, well, you're saying exactly, but all you had to do was complete this probation. And I don't know if you would be a good influence on your son because I don't know if you're still using drugs or not.
I understand that, Your Honor, but I feel like this has been the longest I've ever been locked up my whole life, and I think I've changed a lot, and I think I've learned the lessons that I need to learn to go out there and work and be there for my children.
You haven't learned any lessons because we're here on another motion to revoke. And I always tell people, if you're not going to be clean and sober for yourself, which that's how you should always be, do it for your children. If there's somebody else you love more than yourself, do it for them. And you're not even doing it for your children.
I am, Your Honor.
And so that is why your son is having problems because you're in and out of his life. Sometimes you are there. Sometimes you have motions to revoke. Sometimes you're using drugs. Sometimes you're not. That's instability for your child. And I'm not going to reduce this, and I'm not giving you a judgment satisfied. I'm finding 28 true, going to find you guilty, revoke. I'm going to sentence you to 3 years in the prison, give you credit for any time served. I'll request the therapeutic community. She'll receive any credit for successful inpatient treatment.
Very well, Judge.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, I did.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
We can go off the record. When you're released from prison, if you can't find a sober house, if you can't find someone that can help you, if I'm still here, you come back here, I'll pick up the phone, call somebody to try to get help for you, okay?
Alrighty, thank you.
All right, you're welcome. Good luck to you.